I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my dreamy co-host, Brett.
Hi, Alice. I am almost asleep, so dreamy is a really good description. I will be dreaming here in another hour or so. We got to knock this episode out and then straight to bed.
We're going to knock this episode out because the number of very nice 5-star reviews we get about how dreamy you are is kind of nauseating, but it's so sweet. So many people find you dreamy.
Well, that's the good thing about having a podcast as opposed to a video show like on YouTube, because they don't have to look at me. They can just listen to my voice and imagine how in shape and young I am.
Yes, for both of us, which is great. But, guys, we are so excited to welcome you back because on our other podcast, we just finished a 7-part series on Casey Anthony on the Prosecutor's Podcast. And you guys raised some really, really good legal questions from the case. Don't worry, we're not going to talk more about the facts of that case. But I think that case, because it went through a trial and ended in an acquittal, kind of generated a lot of good questions about basic constitutional rights and basic legal rights you have when you have been through and exercised your right to a trial in a criminal case. Brett, I was so impressed actually with the level of these questions because I do think it's important to understand the intricacies of it. And we forget that these are basics to us because we went to law school. But I think because they are your constitutional rights, everyone should know about these principles.
Yeah, when you live it every day, sometimes you forget that some of the things that we think of as the sort of baseline principles, a lot of people have never heard before, or they've been confused by media and television and everything else. And so it's really good to hear from you guys where you point out things where we make assumptions or we just talk as if everybody knows this when they don't. And we really wanted to take a moment to address some of those because it's not just this case. It's every case you're ever going to hear about in true crime. And there are little intricacies to some of this stuff that are pretty interesting. So we did want to take some time to use Casey Anthony as a vehicle to talk about some of these very basic but very important legal principles.
Yeah, so let's go ahead and dive right in. I'll give you a very brief factual background about why this question came to us. If you may remember from our 7-part series, we said that there was this famous search in Firefox that came from Casey Anthony's password-protected computer. And the search was for foolproof suffocation. But what we also revealed to you guys in the episodes was that the jury did not hear about this search because the prosecution didn't know about this search at the time of the trial. So you guys asked a great question, and that's if there is newly discovered evidence, such as the internet search we just talked about, can Casey be tried again? Brett?
Yeah, I mean, the answer is no. She can't be. And this came up a lot because people, they were like, is there still an investigation? Can they look into this? Is it possible to charge her again? But, the problem is in the United States, we have something called double jeopardy. Now, this is not true in every country. There are other countries that don't have double jeopardy protections. But in the United States, at least, there is a constitutional rule that says that you can't be tried twice. And what it actually says, it's in the Fifth Amendment of the Constitution. A lot of your personal rights that adhere to you when you're involved in some sort of criminal investigation will either be in the Fourth, Fifth, or Sixth Amendment. So this one's from the Fifth Amendment. The Fifth Amendment is most famous for not having to testify against yourself, so pleading the Fifth. But the Fifth contains other things such as this. And what it says is, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. And that has been interpreted to mean that if you are acquitted of a crime, you can never be tried for that crime again. You could stand up. I mean, Casey Anthony could have stood up right after the verdict and said, you guys are a bunch of morons. I killed her. I planned it for years. I finally pulled it off, and now I'm going free. She could have done that, and there is nothing that could be done about it. She's been acquitted. She can never be tried again.
Yeah, and you can understand why this is the case. You don't want people, even people who have been charged with criminal offenses, to always be looking over their shoulders and have no finality. There's something inherently unjust about that. We always talk about finality in the court system, right? That's why there is a Supreme Court, the last word, and that you don't have a million appeals, endless appeals. There are statute of limitations that limit the time in which you can bring a charge. All of these things exist in the law in order to guarantee finality for this kind of innate fairness purpose, not just for the defendant who's charged, but also for the witnesses who may have to testify, and also for the victims to have a final answer in this type of case.
And we talk about this sometimes. We talk about the system. We talk about when we're defending the system. And there are people who want to change it to make it easier to be acquitted or to make it easier to get a new trial. And we always talk about the reasons why that's problematic. And some of them Alice just mentioned. And just to show you that it's not just we want to make it easy on ourselves, this is another place where this is a very important principle of our justice system and needs to be protected. It was a little surprising to me how many people were ready to just throw away double jeopardy and say, double jeopardy is dumb. We don't need that. And we had some very, helpful listeners from other countries that I'm sure have wonderful justice systems that pointed out their justice system doesn't have double jeopardy. I pointed out some of the frailties of their justice system as well, but nevertheless, and why do we need this? And Alice just pointed to some very important things about finality and why that's so important, but there's other things too. Remember, this is a protection. This is a fundamental protection you have. Imagine a system where the government could decide to target you and try you over and over and over and over again until they finally found a jury that would convict you. Is that a system you want to live under? Do you want to spend thousands and thousands of dollars on an attorney for your first trial, and then your second trial, and then your third trial, and now you're bankrupt, and now you don't have any money, and now you can't afford an attorney, so you get an appointed attorney, and maybe that attorney you win with too, but eventually you lose? Is that fair? Is that justice? When you then go to jail for the rest of your life after you were convicted, after the 8th jury trial that you had, or maybe you get the death penalty, was that fair? Is that just? Is that a system you want to live under? And when you say things like, the system is broken because we can't try Casey Anthony again, it is so dangerous, and I don't care what it is you're talking about. When you're using one example of an injustice, or where justice wasn't served, or where the wrong person was convicted, or whatever it is, when you're trying to use that to justify getting rid of a protection, you have to remember why the protection exists in the first place and what the consequences will be. Yes, maybe that second jury would have convicted Casey Anthony. We would have been happy about that. That would have been a more just outcome. Is it worth it to lose this protection for the other 350 million Americans who don't have to worry about being tried again and again and again for a crime? Personally, I think double jeopardy is really important, and it was a great addition to the Constitution, and it's not something that we should be messing with.
Absolutely.
Now, there is one thing about double jeopardy that's important to remember. It's all about the sovereign, and we've talked about the states and the federal government before. And the states and the federal government are separate sovereigns. And this is really hard for a lot of people to understand, even as much as we hammer it. The states are incredibly powerful in the constitutional system. So is the federal government. Each jurisdiction, whether it's a state or federal government, their courts are separate and apart. So, for instance, take the Rodney King case. In the Rodney King case, you had some police officers who beat Rodney King. It was caught on videotape. It was a seminal moment, sort of civil rights in America. Those officers were tried in California state court, and they were acquitted. And you might think, well, that's the end of it. They've been acquitted. They can never be tried again. And that's true in California. However, the federal government, there are civil rights laws. They are a separate sovereign. The federal government can try those same police officers, and did, for violations of Rodney King's civil rights. That is not a violation of double jeopardy because it's a different sovereign who was prosecuting the same individual for what might seem like the same crime, but in fact, one is a state crime and one is a federal crime.
Yeah, that is a great point to make, because sometimes people may miss the difference between a state sovereign prosecuting and the federal government prosecuting, and they can come from the same nucleus of facts, result in very different charges, and there's no double jeopardy. But one thing I do want to know, prosecutors and sovereigns, governments, have limited resources. So if one of the sovereigns, if the federal government or the state and locals charge someone, that factors into the other sovereign's thinking as to whether they should expend additional resources to go after the same person. So you may often hear about this when a prosecution at one of the levels has failed and there's public outcry. Then perhaps if it failed at, say, a state charge, the federal government may come in because it's not a waste of resources, perhaps from their perspective, because the person hasn't been punished or held accountable for the actions, and there's nothing holding them back with respect to prosecuting them under the principle of double jeopardy. But if the person was already charged and convicted, say at the state level, and they've been sentenced to, say, life in prison, it factors into, another sovereign's thinking in their limited resources. Do we really need to go after this person when they've already been tried and convicted in the state court and they're going to be serving the rest of their life in prison? Is this a good use of our resources and time? So just because you can doesn't mean you always do go after them if you are federal versus state and vice versa.
And another very small tweak on this doesn't apply to civil actions. So just because you're acquitted of a criminal offense doesn't mean you can't be sued for the same thing. O.J. Simpson's a good example of this. O.J. Simpson is acquitted in criminal court where the standard is beyond a reasonable doubt. He was then sued by the Goldman family and was found responsible for Goldman's death in a civil lawsuit, which of course is just a preponderance of the evidence. It's not beyond reasonable doubt. So double jeopardy doesn't apply in that way. The civil lawsuit is a different thing from the criminal lawsuit. And just because you succeed in a criminal trial doesn't mean you're going to be immune from a lawsuit later on.
Is anyone else's head spinning yet? All I can think of is people like smacking their heads and thinking, oh, lawyers.
I mean, it's, very, okay. If you're tried in state court and you win, you can't be tried again. But you might be tried in federal court and you might be sued. That's the rule. That's the rule. Casey Anthony, there's no one to sue her, number one. I mean, her parents certainly aren't going to do it. Number two, there's no federal murder statute, so she's not going to be tried federally. And she won in state court, so she's not going to be tried in state court. And the other thing you can't do is have the whole trial, lose the trial, and then try and bring different kinds of charges. Like you can't say, well, we lost the murder and the aggravated child abuse, so now we're going to just charge her with regular child abuse. And that's really one of the reasons you see lesser included offenses is you're never going to get to charge those, so you might as well have them as lesser included offenses in the trial. And so in Casey Anthony's case, as we pointed out, she was acquitted of basically everything she could have been charged with, so there really is no way you could charge her again. So to the extent people were thinking maybe there's still a way to get to her, it's over. It's over. She won. It's over. There will never be justice for Kaylee, and that's just the way it is. And it's unfortunate, but there's nothing that can be done about it. And that led people to the second question that they were asking us. The jury obviously got this wrong, and so the thought some people had was, well, look, the jury's there, but there's a judge there too. Can't the judge issue some sort of judgment notwithstanding the verdict and overturn what the jury has done? And I think this thinking is coming from civil law. So in civil law, if you are sued, the judge can decide that whatever the jury decided is wrong and can issue something called a judgment notwithstanding the verdict, overturn the jury's decision and rule for the other side. He also can do things, there's remittiture and there's another one that ends in ter, where the jury can give you a certain amount of damages and the judge can either lower those damages or raise those damages. Basically, in a civil case, the jury's there, and that's great, but the judge has a lot of power over deciding at the end of the case, okay, jury, obviously your emotions got the best of you. I'm going to deal with that. That's civil law.
And you'll see that a lot in civil law because we will see civil juries fined for, say, the plaintiff in a damages suit. and ask for some damages that is far and beyond anything the statute allows. They're like, it is because of you that this person has lost their arm. 50 million or $1 billion. You often actually see those types of situations, and the judge often steps in and kind of corrects the just result.
The funny thing is, I remember the hard one, which is remediator. It's additor, which I don't know why we use these weird terms, but additor means you can add to whatever the jury's verdict is. If you're the judge, if it's the opposite, if you think the jury clearly didn't understand the damages here and you want to raise them, you can do that. That's a civil case. In a criminal case, the whole point of having a right to a jury means you have a right to a jury deciding whether you are guilty or innocent. If the judge could just say, man, you people are morons, you are totally wrong, I am reversing this, Casey Anthony, you're guilty and you're getting the death penalty. If you had that, then the right to a jury wouldn't really mean anything. And so in a criminal case, if the jury says you are not guilty, and this is important, if the jury says you are not guilty, that is it. It's over. There's nothing the judge can do about it. On the other hand, if a jury says that you are guilty, in that case, the judge actually can overturn the verdict of the jury if it is very clear that no reasonable jury would have found you guilty beyond a reasonable doubt.
You can see how this is all in place to protect your constitutional rights as the defendant. So if you are cleared and it's completely unreasonable based on the facts, judge can't do anything because you're free to go. And we don't stand in that space of violating someone's constitutional rights. They get off, but that doesn't violate your constitutional rights. The flip side, there are devices in the rules in order to allow the judge to do something about this. So typically it's going to be different with each state, but at the federal level, usually what you will see at the close of the prosecution's case in chief, the prosecution will say the government rests. And at that point, the defense, before they put on their defense, if they're going to put on any, have to affirmatively raise, just before the judge, not before the jury, a motion for judgment of acquittal. Essentially what they're saying is, judge, these are the legal elements, and they have failed to present evidence, facts that support all of the elements. So kind of on its face, there's no way that they have mustered past the bar in order to let this even go to the jury. And let's say that you did leave out, a very important part. Maybe you had to show something was knowing, and there was no evidence, no testimony, nothing elicited in the prosecution's case to show that it was knowing. Then the judge can say, yes, there was not evidence to show, the knowing prong of this offense, and therefore I grant judgment of acquittal to the defense. That means the judge is cutting it off and not letting the jury decide. But you can see it's a pretty low bar for the prosecution to have to overcome.
And it really is. It's a very low bar, and there's a reason it's a low bar. If the judge, at the close of the government's evidence, decides that the government hasn't met its burden and acquits the person, then that's it. It's over. The government can't appeal that. The person is free. They are innocent. So judges are very wary about doing that. They would rather, if it's close, if there's really even any argument that the government has proven its case and met its burden, judges really want to let it go to the jury and let the jury have an opportunity to weigh the case. Even if the judge thinks probably not guilty, even if he thinks that, he or she likes to let it go to the jury, let the jury decide, and see if the jury sort of quote unquote gets it right. And in that case, the judge doesn't have to do anything. It's sort of like the system worked the way it was supposed to.
Now, if the judge isn't sure, they can reserve judgment on that motion. But note, the defense has to move for this motion. It doesn't just sua sponte occur, and the judge isn't going to sua sponte grant judgment of acquittal. And so we actually have seen, ineffective assistance of counsel cases brought because the defense counsel failed to move for judgment of acquittal at the close of the prosecution's case. And it's not per se ineffective assistance of counsel not to, but it is a pretty formulaic thing that every defense counsel knows to do to preserve that ability to raise it later, because there are other things you can do after the fact. Let's say the judge reserves judgment and says, I'm not sure yet. The judge can then rule on that motion later on, but he or she has to make the decision based on what the evidence was at the time the motion was made. So he can't then factor some other evidence in later. And some judges will do this. Maybe they have to think about it. They have to do some legal research, what have you. But even if the jury comes back with a guilty verdict, the judge can still set aside the jury verdict and grant the judgment of acquittal.
And there's a couple interesting things there. Number one, Alice is 100% right. So the judge can decide, sorry, jury, you said they're guilty beyond a reasonable doubt. Clearly, I didn't do a very good job telling you what reasonable doubt is because there's tons of doubt, and acquit that person. Interestingly, because the jury has returned a verdict of guilty, the government can't appeal that. So the government, unlike if the judge decides before the jury makes a decision, the judge acquits you before the jury, it's over. If the jury has said you're guilty, the government can appeal, and an appellate court could say, sorry, trial judge, we actually think you're wrong here. The jury got it right, and then the conviction is reinstated. So that's an important distinction. It's a very powerful thing that a judge can do, acquitting someone before it ever goes to the jury. The second thing that Alice mentioned that's important, and this is kind of hard to wrap your head around, it is the government's burden to prove you're guilty. So imagine a situation in which the defense makes that motion for acquittal at the conclusion of the government's case, and the judge denies it. And then they put the defendant on the stand, and he testifies, and it's terrible, and it goes horribly for him, and everything he says proves beyond a reasonable doubt that he's totally guilty, and then he's convicted. The defendant can still appeal and say, you should have granted my motion at the conclusion of the government's evidence. And you can't use the fact that I then got on the stand and was a total moron afterwards, because the government has to prove its case. Do you see what I'm saying? So the fact that if the government didn't prove its case, the government didn't prove its case, and it loses. And the fact that later on, after the whole case should have been dismissed, the defendant then gets on the stand and messes everything up, that doesn't mean that you can't review that initial motion for a judgment of acquittal just based on what the government has provided. Now, once again, it is a very low bar for the government. The government doesn't have to put on much. So it's going to be very rare that you succeed in that case, but it's just sort of an interesting, quirky little bit of the law. The bottom line here is, if the jury finds you not guilty, you are not guilty. There is nothing the court can do about it.
So that's what happened here in the Casey Anthony case. Of course, the jury came back as not guilty. So kind of to sum this all up, basically, the judge, if it's a not guilty verdict, the judge can't do anything about it. And if it's guilty, the judge can do something about it and set it aside to acquit the person. But generally, on motions for judgment of acquittal, what the judge is called to do is not to weigh the evidence to see if the person is guilty based on the evidence on both sides, but to only look at the prosecution's case and hold the government up to the burden it must meet in order to prove the case. So this is interesting because another question that kind of blends into what we've been talking about, if Casey Anthony tells her lawyers that she's guilty, are they under some obligation to disclose that to someone? Short answer, no. So this is because from the defense's posture, the question is not, did Casey do it? The question is, can the government prove that Casey did it? Because the burden is always on the prosecution to show that the defendant has committed the crime. So even if Casey did it and the government failed to prove it, didn't show the elements, didn't bring evidence, just stood there, didn't even go to trial, didn't put on a prosecution with evidence and testimony, then she's not guilty, because it is the burden on the government to show that she committed the offense. Now, let's say Casey tells her lawyers, oh yeah, I totally did it. They do not have to disclose it to anyone. However, all lawyers are bound by model rules of conduct and ethics. Each state bar will have their own rules, but generally they're all going to be about the same. And that is, her lawyers and any lawyer has to make sure that Casey or their client does not produce false evidence. So evidence that the lawyers know to be false. And second, that they cannot let their client perjure themselves. Now, what are you going to do if your client does this? Because trust me, clients will do this, especially if you're in criminal defense. Your defendant probably will lie at some point. If you know that they are lying, if they are perjuring herself. So let's say Casey says to the lawyers, I killed Kaylee. And then Casey decides to take the stand, which she did not do in this trial. But let's say she takes the stand and she proceeds to say, I have no idea what happened to Kaylee. I didn't see her that day. I did not kill her. The lawyers have knowledge that she's lying and therefore committing perjury. They first have to counsel their client and get her to basically see the error of her ways, withdraw what she said, correct the record so that she is no longer perjuring herself. And if that doesn't work, they then have to bring that to the attention of the other side and the judge. And in some instances, it may lead to the attorney having under ethical obligations to withdraw or to ask to be allowed to withdraw or have additional counsel come in because they can't be part of the perjury.
And this is where it gets kind of complicated when you talk about the lawyer's ethical obligations. We talked about this a little bit in a previous episode, but, some lawyers, you'll hear them say things like, I never asked my client if they did it and I don't want to know. I tell them, I don't want to know if you did it. And this is one of the reasons, because it really does hamstring you to know too much about your client. But assuming you don't have a situation where the client wants to perjure herself or whatnot, if your client tells you they did it, assuming that they allow you to craft your strategy in a way that comports with their ethical obligations, you never have to tell anybody that they told you that. In fact, you're obligated not to. Under attorney-client privilege, you have a responsibility forever and all time to not reveal what they told you. You guys may remember last October, we did the Lizzie Borden case. Lizzie Borden case is 100 and something years old, but the law firm that represented Lizzie Borden still exists. And they have all these files about the case. And to this day, they will not release those files, even though they would be incredibly helpful for the historical record, because they maintain that their obligation to Lizzie Borden to protect the confidentiality of their client continues to this day, 100 years after she died. And that is the way most lawyers look at it. They have an absolute obligation not to reveal the things that their clients told them, assuming they're able to do so consistent with their other ethical obligations.
And this all makes sense because we've said this many times. The Supreme Court has said everyone deserves, and when it comes to your criminal rights, deserves representation. And another ethical obligation that all lawyers have is to zealously represent your client. And so zealously doesn't mean committing perjury or lying or making up evidence, but it does mean even if you know they did it. And you know what? Think about a less kind of inflammatory case. Think about a simple gun case. The guy was like standing on the side of the street. He's not supposed to have a gun, and he's literally arrested with the gun in his hand. Like, I think there's no question about whether he had the gun, but he has a right to trial. And his defense lawyer may look at the video and the picture and he's like, you clearly had the gun in your hand. There's no question about it, but that doesn't matter. They get to hold the government to the standard of proving that they did it beyond a reasonable doubt.
Now, where this gets complicated is when there's evidence involved. So here's another question. Let's imagine that Casey gave her lawyers evidence that proved she killed Kaylee, say the bottle of Xanax or the roll of duct tape. Are they required to turn it over to the prosecution? So basically the question is, if you got a bunch of evidence that's going to convict you, can you just give it to your lawyer and then be protected by attorney-client privilege and voila, I'm good. Now the government's never going to get that evidence. It is not that easy. Although attorney-client privilege protects you in a lot of ways, including a lot of the things you can say and a lot of things you can give to your attorney, it doesn't protect you in two really important ways. The fruits of the crime and contraband. Say you rob a bank and you give your attorney a bag of the money that you stole from the bank. Or let's say you're dealing in cocaine, and so you give your lawyer a briefcase full of cocaine. The lawyer is not only ethically obligated, but is subject to criminal penalties if he does not turn that over to the government. Now, what's interesting about this, he gives it to the government. He didn't have to tell them anything. He doesn't have to tell them how he got it, where it came from. All he has to do is make the evidence or the contraband or the fruits of the crime available to the government. So basically, your lawyer would just show up in the prosecutor's office and be like, here's a briefcase full of cocaine. and the prosecutor could be like, where did you get it? Can't tell you. And the prosecutor might try and subpoena this person and all this other stuff. They can't do it. Another story from law school. I don't know if I've told this one or not. So my criminal law professor was Alan Dershowitz. And basically, criminal law was Alan Dershowitz's story hour. And he would just tell us stories, and that's how he kind of taught. Like, he'd been a criminal defense lawyer for a long time, been in a lot of famous cases, and so he would teach these cases that way. And so he told us a story about how there was a kid who at Harvard was like the main dealer of marijuana. And he dealt marijuana to basically everybody on campus, both at the law school and at the college. And he made a lot of money doing it. But he was very civic-minded, very liberal. He believed in paying taxes. He believed in supporting sort of the government and its social programs. And so he goes to Professor Dershowitz and he's like, I want to hire you as my lawyer. So they write up a little contract. Dershowitz becomes his lawyer, and Dershowitz says, okay, what is it you want to talk to me about? And the guy says, I sell $10,000 worth of marijuana every month, and I want to pay taxes on it. And so Dershowitz is like...
What an honest guy.
Exactly. Dershowitz is like, okay, so what he did is at the end of the year, they got together, they figured out everything, his costs, his profit, what tax bracket he would be in, how much he would owe. They filled out an IRS form. They left off his name. They left off all his identifying information, because you can do this. You can, apparently, who knew this? You can file your taxes anonymously, which he did. And then they sent basically like $30,000 in cash to the IRS. And in the form, in business, it was dealing marijuana. You know, marijuana seeds cost this much. You know, marijuana from the Mexican cartel cost this much. I mean, it was literally, they just laid it all out. All honest, all forthright. They send it in, and about a month later, a DEA agent shows up in Alan Dershowitz's office and asks him all these questions, wants to know who this is. And he's like, I'm not going to tell you that. He's my client. I don't have to tell you anything. And eventually, they just had to leave. There was nothing they could do. They could not force him to reveal any of this information or anything else that his client had told him, because he had followed all the rules. And it's the same thing here. If you have the fruits of the crime, if you have the contraband, like if he had given a bunch of marijuana to Dershowitz, he would have had to turn it over to the DEA agent, but he wouldn't have had to told him where it came from. The same thing is true of instrumentalities of the crime, and that's really what we're talking about here. So the duct tape, the Xanax. If your client gives you the gun that was used in the murder, you have to turn that over to the prosecution. There's some wiggle room here. Contraband and fruits of the crime, you have to immediately turn it over. You cannot hold on to that. Instrumentalities in every state, it's just a little, it's like within a reasonable time. I mean, there's sort of a thought, you're going to need to think about this. How are you going to do your defense? What are you going to base it on? But eventually you have to make it available to the prosecution, even if doing so makes it very clear who did it. Usually with fruits of the crime and contraband, you're not necessarily giving them much of anything. If the bank was robbed and you give them the money, well, now they got the money, but that doesn't really tell them much about who did it. Obviously, with instrumentalities, it's going to be more likely that doing that actually reveals something about your client. You know, if your client gives you a roll of duct tape and you turn it over, now they are going to be able to figure out where that duct tape came from, maybe who bought it. You know, all sorts of evidence is inherent there. And so it's a little bit worse for your client, but the rules remain the same. If you've got that evidence, that physical evidence, you cannot hide it from the government. You have a responsibility, just like the government does, to provide evidence of the crime that you have to the government in a timely fashion.
That was so well said, Brett. What I hope you can see from all of this, and I think it's right, all of these rules exist in place to protect the defendant, to allow the defendant to have zealous advocacy even when from the outside lay world it looks like they clearly did it, because that is not enough. Our Constitution says just because everyone saw it or everyone thinks clearly this person did it, that's enough. The burden is still on the government to prove it, and we're going to give every advantage to the defendant before a trial in order to make sure we get it right.
And I think it's a really important thing to remember, because there's so many people who feel like the dice is loaded and that they are loaded against the defendant. And it's just really not true. There are many advantages for the defense. There are many protections for a defendant. There are many opportunities to get it right. It doesn't always work out that way. There are mistakes that are made, but the system is designed to make it hard to prosecute someone and hard to convict someone. And you want it to be hard, but you don't want it to be impossible, and you don't want it to be so difficult that criminals are regularly getting off and victims aren't getting justice. You don't want a situation, frankly, like Casey Anthony. Casey Anthony is a failure of the justice system. Because it's a failure, though, doesn't mean we need to make wholesale changes. Every system will have failures. Every system has shortcomings. And it is really important to look at the system as a whole and the way it works and why it works the way it does before you start thinking, man, we need to tear the whole thing down, because we, as a society who right now are not really good at figuring anything out, are somehow going to build a better justice system. I think we need to be very careful when we are tinkering with the system to make sure that we preserve the things that work and work really well.
Wow, these were awesome questions, truly. These are like law school level questions, and we're so glad that you thought to ask them to us. We hope we've answered some questions here. And like we said, even though we're using the Casey Anthony case and trial as a basis to talk about these questions, these are legal principles that extend to all criminal cases. So we hope you've learned something today. And as always, write in with your questions. We love hearing from you for both the Prosecutors Podcast as well as for Legal Briefs. We are really listener driven. And thank you guys for your great support. Brett, do you have anything else to add?
That's all I have for today. Thank you guys so much for helping make this such an easy show to do. You give us topics all the time, and it just feels like there's just unlimited things to talk about. This one's a little nerve-wracking because the thing about the true crime show we do, there's always going to be cases. There are cases until the end of time. And sometimes you feel like, in this one, are there always going to be topics for us to talk about? But you guys do such a great job of providing them. So thank you so much for making this show such a joy to do.
Well, until next time, thank y'all for joining us. I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Briefs. Your wife can brew you bourbon, and I make an excellent fried rice from day old rice.
Oh man, I bet it's so good.
I'll brew you some. There's not much left, I'm not gonna lie, because everyone
Does everybody loved it that much? My roommate's mother, who was from China, made the Chinese food that was just so good. The first time I went over there, I'm thinking, sweet and sour chicken and Kung Pao chicken or whatever.
No way.
That was not what it was, but it was really good. Opened my mind, opened my eyes to the possibilities.